Imagine using your YouTube ad revenue as a literal legal weapon.
Right, to force the United States Department of Justice to cough up the Jeffrey Epstein files, of all things.
I mean, it sounds like the plot of a legal thriller.
Yeah.
But it is happening right now, in real time.
Yeah, it really is.
So today, we are unpacking this incredible, high-stakes legal chess match between an independent journalist and the federal government.
And, before we get into the actual mechanics of how this is all unfolding, we really need to establish a very clear baseline with you, the listener.
Definitely. This is super important.
Right, because the material we are exploring today for this deep dive, it centers on a recent YouTube interview from Katie Phang's channel, and it features independent journalist and former trial lawyer Katie Phang.
Yeah.
And this discussion involves some highly sensitive, frankly, very politically charged allegations. They implicate some really high-profile figures.
We're talking former President Donald Trump,
Yeah.
current top officials at the DOJ.
Exactly. So our role here today is absolutely not to take sides. We're not endorsing, we're not validating the viewpoints presented in that interview.
No, not at all.
Our mission is strictly to act as your impartial guides here. We're just reporting the factual contents of the source material provided so that you can understand the sheer scale of the legal and institutional dynamics at play.
Yeah, we are basically just here to map the maze for you.
Precisely.
Okay, let's unpack this.
Yeah.
Because when you look at the situation, I think the best way to understand it is to imagine finally being handed the keys to this massive locked vault that you've wanted to open for years.
Oh, I like that analogy.
Right. But then you put the key in the lock, and you realize the door has been superglued shut from the inside.
What's fascinating here is that the standoff over that vault, it isn't just about the dark secrets or the salacious details sitting in the dark. It's actually a fundamental stress test of American institutional transparency. I mean, we are watching a live collision between traditional government structures like the DOJ and this relatively new frontier of independent media.
It's totally wild.
It's a masterclass in what happens when a single citizen decides to use the system's own, rigid rules to demand accountability.
So let's start with the law that was supposed to swing this vault wide open in the first place.
Let's do it.
Back in November of 2025, Congress passed the Epstein Files Transparency Act.
Right, the bipartisan bill.
Exactly. It was pushed by Congressman Tom Massey and Ro Khanna. And the mandate they wrote into this law was absolute. I mean, they ordered the Attorney General to release all Epstein files in the government's possession by December 19th, 2025.
But, Congress knew that a blanket demand without any guardrails would just never survive court challenges.
Oh, of course not.
So they built in very specific rules for what the DOJ could and could not redact.
Right, like they could withhold classified docs for national security, obviously.
Yes, national security was protected. And they were also allowed to redact info to protect the private, confidential information of victims, which makes total sense.
Totally.
But here's the critical part. The law included explicit language prohibiting the DOJ from redacting names simply to spare someone from public humiliation or shame.
Wow. So they explicitly said you can't hide a name just because it's embarrassing?
Exactly. If a name was in those files and that person wasn't a victim or a verified national security asset, the law dictated that the name gets published.
So the era of protecting powerful people from embarrassment was supposedly over.
Supposedly.
Except the DOJ's response didn't exactly honor that spirit, did it?
Not even a little bit. So under then Attorney General Pam Bondi, who we should note was summarily fired, and now under the acting Attorney General Todd Blanche, the DOJ released about 3 million documents.
3 million?
Yeah, but the total estimated universe of documents is around 6 million.
Okay, so they handed over roughly half.
Right. And then in January of 2026, Acting AG Blanche basically declared that the DOJ was simply done complying with the act.
Just done.
Just done. He claimed the remaining 3 million documents were either duplicative or they were non-responsive to the law.
Okay, well, I have to play devil's advocate for a second here.
Go for it.
Because 3 million documents is a staggering amount of data. I mean, from the outside looking in, shouldn't we be somewhat satisfied that a notoriously secretive government agency released 3 million pages of literally anything?
I mean, it looks like a massive victory if you are only measuring transparency by the sheer weight of the paper.
Right.
But in legal terms, volume does not equal compliance.
That's a good point.
Think of it this way. If I owe you $10,000 and I hand you 5,000 pennies, I mean, I have given you a massive pile of coins.
But you definitely haven't paid your debt.
Exactly. And Katie Phang, leveraging her background as a trial lawyer, she didn't just accept the 3 million pages and say thank you. She started really digging into them.
And what did she find?
She immediately noticed severe inconsistencies. She found that redactions were scattered, they were illogical. Names were being hidden that legally should not have been hidden under the Transparency Act.
Oh, wow.
And even worse, she found instances where names were exposed that absolutely should have been protected as victims.
But, I mean, what does that actually tell us, though? Is the DOJ just, like, really bad at paperwork?
Well, it suggests one of 3 deeply concerning scenarios.
Okay.
First, it could simply be gross negligence, a sloppy rush job by overwhelmed clerks.
Sure.
Second, it could be a massive technological failure, like perhaps they were relying on an artificial intelligence tool to handle the redactions at scale, and the AI just failed miserably to understand the context.
That honestly wouldn't surprise me.
Right. But the third possibility, and the most alarming one that Phang raises in the interview, is intentionality.
Intentionality, like they did it on purpose.
Yes. There is a real concern that the DOJ might be weaponizing the redaction process to intimidate or coerce people into silence.
Oh, I see.
Because if you expose the names of certain victims while hiding the names of the perpetrators, you send a chilling message to anyone else who might even consider coming forward.
Yeah. That is incredibly dark. So the DOJ drops their 3 million pages, they slam the vault shut, and essentially say, deal with it.
Pretty much.
And if this were 5 years ago, that might just be the end of the story. A journalist might write a frustrated op-ed, and the news cycle would just move on.
Totally.
But Phang didn't just write an article. She actually filed a federal lawsuit in late April of 2026 against acting AG Todd Blanche.
She did.
But she immediately ran into this massive legal roadblock. The Epstein Files Transparency Act has no private right of action.
Right.
Can you explain what that actually means for us? Like, why can't a citizen just sue the government when a law is obviously being broken?
So a private right of action is a very specific clause written into a statute that authorizes an average citizen to sue if the law is violated. Congress puts it in some laws, and they purposefully leave it out of others. And the Epstein Files Transparency Act did not include one.
Interesting.
The courts use this as a strict gatekeeping mechanism. It's to prevent federal judges from being just flooded with millions of lawsuits from random citizens every time the government makes a misstep.
Okay, that makes practical sense.
Yeah. So under normal circumstances, a citizen like Katie Phang cannot just walk into a federal courthouse and demand the DOJ comply with this specific act. The judge would throw the case out immediately.
Saying she doesn't have the right.
Right, saying she lacks the statutory authority to bring the complaint.
Wait, I'm confused then. If the Transparency Act specifically does not let regular citizens sue, how does she get into court at all? How does pointing to a totally different law magically open the courthouse doors?
This is where the legal maneuvering gets just brilliant. Phang teamed up with lawyers from the Public Integrity Project, specifically Brendan Bellew and Sam Ward-Packard. Because they couldn't sue under the Transparency Act itself, they pivoted. They used the Administrative Procedures Act, or the APA.
The APA?
Yes. The APA is essentially a foundational catch-all law. It allows citizens to challenge federal agencies in court when those agencies act in a way that is arbitrary, capricious, or not in accordance with law. So they aren't suing because the Transparency Act allows them to. They are suing because the DOJ, as a federal agency, is allegedly acting unlawfully under the broader rules of the APA.
Okay, so they find a backdoor through the APA. But there is still another massive hurdle here, right? Because even with the APA, she had to prove standing.
Exactly. Standing is the ultimate constitutional bouncer at the door of the American legal system.
Right.
You can have the most righteous clause in the world, and you can point to an agency breaking the law. But if you cannot prove that you personally have suffered a concrete, particularized injury because of that broken law, you do not get in.
You can't just be mad on the internet.
Exactly. You cannot sue just because you are angry as a taxpayer. Phang had to prove the DOJ's secrecy was injuring her specifically.
And her argument for how she was injured is so fascinating. She claimed 2 distinct types of harm.
Right. She did.
First, informational harm. She argued that the DOJ's improper sweeping redactions act as literal roadblocks, preventing her from gathering the facts she needs to do her job as an investigative journalist.
Which makes sense.
But the second harm she claims is where this gets incredibly modern. She claimed economic harm.
This is the genius part.
Because Phang is an independent journalist. She isn't salaried at a massive legacy television network anymore. She makes her living directly through her audience on platforms like Substack and YouTube.
Right.
Her argument to the court was simple. She basically said, if I cannot access these unredacted files, I cannot write my Substack posts or produce my YouTube episodes. Therefore, I cannot earn my income.
And we should clarify for the listener, she is not suing the government for a financial payout here.
No.
She doesn't want damages or a check from the DOJ, but she is using the documented loss of her own ad revenue and subscription money as the legal key to prove she has standing.
Right.
The financial injury gives her the legal right to demand the files.
It's less like trying to get a speeding ticket dismissed on a technicality and more like realizing the VIP club won't let you in through the front door, so you just buy a single share of the company to get the legal right to walk through the employee entrance.
That is a perfect way to look at it. You are using the strict, rigid rules of the system against itself.
Yeah.
If we connect this to the bigger picture, it highlights a massive shift in the broader media landscape.
How so?
What Phang and her legal team did is they took the direct monetization model of the modern creator economy and they weaponized it into a legal crowbar.
Wow.
By acknowledging that her income is directly tied to her access to information, a federal judge agreed she had standing.
That's huge.
It sets a precedent that gives independent creators immense structural power. It legally recognizes that a person with a Substack and a YouTube channel has the exact same fundamental need to compel government transparency as a massive corporate newsroom.
Okay, so she prized the courthouse door open with this economic argument. Now we finally get to see what she's actually looking for.
The fun part.
The specific document sitting in the dark that the DOJ is fighting tooth and nail to keep hidden.
Right.
So the judge presiding over this case is Senior Judge Emmett Sullivan. Our source material notes he is well known in the legal community. He presided over the Michael Flynn case, and he is widely described as a judge who, frankly, suffers no fools.
He absolutely does not.
He looked at Phang's arguments and granted a preliminary injunction. Let's translate that for a second. What does a preliminary injunction actually do in this context?
Okay, so a preliminary injunction is a judge stepping in before the full trial is even finished and just saying, stop.
Like hitting the pause button.
More like hitting the override button. It means the plaintiff, in this case Phang, has shown such a strong likelihood of winning and such a high risk of irreparable harm if things stay the way they are, that the court is forcing the defendant to take immediate action right now.
Got it.
Judge Sullivan essentially agreed that the DOJ's current stance is indefensible, and he ordered them to address 5 specific battlegrounds immediately.
And these 5 areas give us a very clear, really disturbing map of exactly what the government is withholding.
They really do.
So the first area involves specific emails. Phang identified emails in the initial document dump where the sender and recipient names were redacted, but the contents were visible.
Right.
And the contents discussed absolutely egregious acts. We're talking things like torture videos and horrific discussions about individuals justifying the abuse of 14 and 15-year-olds.
The second area focuses on internal DOJ documents.
Okay.
This includes a draft indictment from the Southern District of Florida that was never actually presented to a grand jury.
Oh, this is the Alex Acosta thing.
Exactly. To give you the context, this goes back to when the then U.S. Attorney, Alex Acosta, gave Jeffrey Epstein that infamous sweetheart non-prosecution agreement.
Which effectively shut down a massive federal investigation at the time.
Right. And Phang is demanding the underlying documents that show exactly how and why that federal case was bypassed. She wants to see the internal government machinery that allowed Epstein to walk.
Now, the third area gets into extremely sensitive allegations. These are handwritten underlying notes for FBI incident reports, which I guess are known in law enforcement as Form 302s.
Yes, 302s.
According to the filings, these specific notes deal with a victim, identified as Jane Doe, who alleges that she was sexually abused and physically battered by Donald Trump when she was 13 years old.
And we are stating that strictly as it appears in the legal filings.
Yes, exactly. But the DOJ stated excuse for not releasing these specific handwritten notes. Acting AG Blanche claimed in court filings that handwriting is simply, quote, too hard to redact.
Too hard, yeah. And then the fourth area involves foreign language documents.
Right.
The Epstein network was a massive international trafficking operation, obviously. Yet the DOJ hasn't bothered to translate or interpret a massive cache of foreign language documents.
And their excuse for that one?
The official phrasing Blanche used to defend this inaction was that translating them was not practicable.
Okay, I have to stop you there.
Yeah.
Because I'm trying to put myself in the DOJ's shoes here.
Okay.
Blanche is the acting attorney general of the United States. Can't he just play the national security or the victim protection card to shut this whole thing down?
You'd think so.
I mean, judges usually defer to the executive branch on things like that, don't they? Why couldn't he just walk into court and say, Your Honor, I am redacting these emails and draft indictments to protect the victims, and just make the problem go away?
Look, in a different courtroom with a more deferential judge, they might have gotten away with a broad stroke exactly like that.
Right.
The government relies on that deference all the time. But Judge Sullivan's specific reaction is what makes this so legally precarious for the Justice Department right now.
Because he's not buying it.
He explicitly told Acting AG Blanche that he does not trust or believe his representations in his filings.
Wow. He basically called him a liar in legalese.
Essentially, yes. The judge is refusing to accept these blanket excuses. When Blanche argues that handwriting is too hard to redact or translating foreign documents is not practicable, Judge Sullivan is essentially looking at the highest-ranking law enforcement officer in the country and saying, tough.
Figure it out.
Exactly. The Transparency Act does not offer exemptions for tasks the DOJ finds tedious or difficult or expensive. The law says do it, so you have to do the work.
Which brings us to the fifth and final area covered by the injunction, and that is a redaction log.
Ah, yes.
Explain why this is so critical, because to me it sounds like a boring administrative detail, but it seems to be the linchpin of the whole fight.
It is the absolute linchpin. The Epstein Files Transparency Act explicitly required the Attorney General to keep a detailed log tracking exactly why each and every redaction was made. If the DOJ blacks out a name on page 400, they must log the specific, legal, statutory justification for hiding that name.
Like, are they a victim or are they an intelligence asset?
Right. And the DOJ completely failed to provide this log.
They just didn't do it.
They didn't do it. And without it, the public and the courts are left entirely in the dark. They're forced to just blindly trust the government.
Which Judge Sullivan clearly does not.
Exactly. You're left guessing whether a name is hidden for a valid protective reason or if it is hidden simply to protect a powerful person from the embarrassment the law explicitly said they must face.
So by demanding the log, the judge is basically forcing the DOJ to show their math.
Show their math line by line.
This sets up an incredible real-world collision course, because according to the interview, this all comes to a head on a very specific Thursday, which is July 30th.
Tomorrow, basically.
Judge Sullivan issued a direct personal order to Todd Blanche. He ordered him to appear in his chambers personally no later than 3:00 p.m. Eastern.
That is highly unusual.
Right. And Blanche cannot just send a lawyer. He has to physically bring the unredacted documents for the first two areas, so the emails and the internal DOJ draft indictments.
Right. The other three areas are pending further orders, but for these two, he has to show up in the room and prove his work.
He has to prove, document by document, that his redactions are legally justified.
And look, Blanche tried every procedural maneuver to avoid the showdown.
I bet.
He asked the judge for a 7-day emergency stay, and when that failed, he asked for a 60-day stay to delay compliance.
And Sullivan said no.
Judge Sullivan denied both of them. He doesn't trust the DOJ's digital filings, and he doesn't trust their blanket statements. So he is forcing the acting attorney general to physically bring the unredacted secrets into the room so the judge can look at them with his own eyes.
The timing here is what turns this from a legal procedural into a full-on political thriller.
Oh, absolutely.
Because at the exact same time Todd Blanche is dealing with a federal judge who does not trust him, he's also trying to get confirmed by the Senate as the permanent Attorney General of the United States.
It's the worst possible timing for him.
So what does this all mean? He is literally showing up for the final round of a massive job interview, but his background check is currently being conducted via a contempt of court hearing.
This raises an important question, right? Because it's a profound vulnerability that highlights the severe convergence of the legal and political stakes here.
Yeah.
If Blanche defies Judge Sullivan's order on Thursday afternoon and refuses to hand over the unredacted documents, he faces being held in contempt of court on the exact same day his nomination is sitting in front of the Senate Judiciary Committee.
And his confirmation is already on incredibly thin ice.
Very thin.
I mean, Senator John Cornyn, a Republican, is acting as a major roadblock on the committee.
Right.
He is allegedly holding up Blanche's nomination because Blanche refuses to kill a $1.8 billion slush fund, and because of some unresolved, pretty tense issues regarding tax immunity for Donald Trump's family and businesses.
And it only takes one holdout on that committee to stall the nomination and prevent it from reaching the full Senate.
So Blanche is caught in an impossible vice.
Completely.
On one side, you have a federal judge demanding ultimate transparency under threat of contempt.
Yeah.
And on the other side, a brutal Senate confirmation process where literally any misstep, either by angering his political allies or by being held in contempt by a judge, could cost him the job entirely.
And what is perhaps the most telling detail in this entire saga is how the public is actually responding to this pressure cooker.
How so?
Katie Phang points out in her interview that despite bringing this aggressive, highly publicized lawsuit that directly implicates major political figures, she has received absolutely zero hate mail or backlash on platforms like Truth Social.
Wow.
Zero. That suggests something remarkable about our current cultural climate. The desire for transparency regarding the Epstein files completely transcends partisan lines.
That is so rare right now.
Even the most ardent political bases seem to recognize that the institutional protection of these secrets just has to end.
It seems to be the one thing everyone actually agrees on.
Yeah, it is.
Okay, let's bring all these threads together. We started with a bipartisan transparency law that was supposed to clear the air, which was immediately met with a stonewalling Defense of Justice Department.
Right.
Then we saw an independent journalist realize the front door was locked, so she took the modern economics of her Substack and YouTube channels, turned that revenue into legal standing, and pried her way into a federal courtroom.
An incredible pivot.
And now we have a federal judge who has completely lost patience, effectively calling the bluff of the highest law enforcement officer in the country, forcing him to physically show his hand.
The ultimate takeaway for you, listening to this unfold, is that this is a stark lesson in civic mechanics. Laws are only words on a piece of paper. They are only as strong as the people willing to relentlessly enforce them.
Yeah.
And this case proves that the definition of the press has fundamentally evolved.
It really has.
It is no longer just massive legacy networks with sprawling corporate legal departments that can hold the government's feet to the fire. Independent creators now possess immense structural and legal power to force accountability, provided they understand the intricate rules of the system and know exactly how to use the tools at their disposal.
Which brings us right back to that vault.
Right.
The door was glued shut from the inside. The government claimed they had done all they could, but somebody finally found the exact right legal crowbar to wedge into the frame.
Yeah, they did.
So as we wrap up, we want to leave you with this thought to mull over. If it takes a single self-funded journalist exploiting a legal loophole about YouTube ad revenue to force the federal government to comply with its own transparency laws, what does that actually say about the current state of our institutional checks and balances?
Good question.
And more importantly, what other massive secrets are sitting in federal vaults right now, just waiting for someone else to find the right crowbar?
A very unsettling but totally necessary question.
Thank you so much for joining us on this deep dive. Keep questioning, keep exploring, and we'll see you next time.